Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to this week's episode of Winning Isn't Easy. Before we get started, I've got to give you that legal disclaimer because the Florida Bar has said to me that I can't give you legal advice on this podcast. But now that I've said it, I assure you that nothing is ever going to prevent me from giving you an easy to understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Now, if you're on disability benefits or you're applying for your disability benefits, there's a lot you need to know. And one of the most important things you need to know is the games that disability carriers play with your Social Security, disability, or retirement benefits. I'm going to talk about three things today. One, what's in your wallet? It depends on what is in your disability policy or plan. Two, can a disability carrier like Aetna deduct Social Security retirement benefits from your ERISA long-term disability benefits? And three, does a disability carrier like Aetna have to explain why it rejected your favorable Social Security decision? Let's take a break for a moment before we get started. Welcome back to Winning Isn't Easy. Can a disability insurance company like Aetna deduct Social Security retirement benefits from your ERISA long-term disability benefits? I read all of the cases that come out every week that involve ERISA, and these are cases across the United States. And I read them because I think it's important not only to keep up with the law, but to learn the games that disability carriers play and how courts deal with these games. So many disability insurance policies allow for the deduction of Social Security retirement benefits from long-term disability payments that the policyholder is entitled to receive. However, the devil is in the details. You should get a copy of your policy or plan to determine whether the Social Security retirement benefits are allowed. So let me tell you the story of Smith versus Aetna and the particular policy in question and what the judge did. This policy provided monthly benefits under the plan that said, and this is a bit confusing, but this is the kind of stuff you'll see in the policy or plan language, that the benefits payable under the plan will be the lesser of the scheduled monthly LTD benefits and the maximum monthly benefits minus all other income benefits, but not less than the minimum monthly benefit. This is sort of like a math equation, isn't it? And not particularly clear either. So what do we have to do? We have to look at the policy terms for the definition of other income, which defined that to include disability, retirement, or unemployment benefits required or provided for under any law of the government, including benefits from the Federal Social Security Act. So in English, this provision allowed Aetna to deduct from Smith's long-term disability benefits any Social Security retirement benefits he received. Now, Smith was a clever fellow, had a clever lawyer who I happen to know, and Smith claimed that there was an exception to the rule that provided that the Social Security retirement benefits that the insured received could be deducted because he was getting those retirement benefits before he became disabled under his long-term disability policy. So he argued that, look, I was getting these benefits before I became disabled, and you, disability carrier, can't reduce my benefits, my long-term disability benefits, by something I was getting before I became disabled. Well, unfortunately, the judge didn't necessarily agree with that. And as in most cases, facts matter. So Smith argued that he should be deemed disabled in February of 2016 because that was the day he became eligible for receiving his monthly long-term disability benefits. But the court noted that the issue was really what was the date Smith became disabled and not the date he became eligible to receive long-term disability benefits. And unfortunately for him, the two dates were not the same. So how did this play out? Well, Smith was collecting short-term disability benefits in August of 2015. He began collecting his long-term disability benefits 26 later, or February 2016. But guess what? He began collecting Social Security retirement benefits in December of 2015, in the middle of this whole time frame. Okay, so he was collecting short-term, then got retirement, then got long-term disability. Again, devil's in the details. The policy says that under the terms of the policy or plan, that the period of disability begins on the first day you are disabled as the direct result of a significant change in your physical or mental condition while you're insured under this plan. So in this case, Smith's date of disability was August of 2015, which was the date he stopped working and he began receiving his short-term disability benefits. Now, he didn't become eligible for his long-term disability benefits until he had satisfied that 26-week elimination period. He argued that I wasn't disabled for long-term disability purposes, but the plan, the language was pretty clear. It said that the date the person became disabled under the plan or policy was before the date, in this case, that Smith was eligible to receive his benefits. So he was disabled under the terms of the short-term disability plan in August of 2015, and his eligibility for LTD benefits didn't negate the fact that he collected Social Security retirement benefits in December of 2015. So he was getting these retirement benefits. Yes, we agree, but retirement is different than disability, isn't it? When you apply for disability, you're saying there's a change in my physical condition. When you're filing for retirement, you're saying, hey, I'm done. I'm not going to work for whatever reason. So they aren't the same thing, quite frankly. And the policy clearly said that the carrier had the right to take the offset based on the date of disability, which began when he stopped work and applied for short-term disability. So I agree with this decision that the court entered, finding that Aetna had the right to deduct the Social Security retirement benefits from his long-term disability benefits. Now, does that mean that the carrier is also bound by a Social Security disability decision and they have to pay benefits? I'm going to answer that in my next session. Let's take a break.